moment to introduce today's incredibly distinguished speaker, Professor Scott Matheson. Few have as broad a background in legal scholarship and government service as Scott, and a list of his accomplishments is remarkable. Scott is currently Professor of Law at University of Utah S.J. Cooney School of Law. He graduated from Stanford in economics, Oxford in modern history as a Rhodes Scholar, and Yale Law School. He served as a public policy scholar at the Woodrow Wilsons International Center for Scholars in Washington, D.C., was Dean of the University of Utah S.J. Cooney School of Law, United States Attorney for the District of Utah, Associate Dean for Academic Affairs at the University of Utah College of Law, Visiting Associate Professor at the JFK School of Government at Harvard, Deputy County Attorney for Salt Lake County, Associate at the Washington, D.C. law firm Williams & Connolly, Manager of 2 successful gubernatorial campaigns, and a legislative assistant in Congressional office. Finally, he was the 2004 Democratic Party nominee for governor of Utah. Please help me in welcoming Scott, who will now discuss his latest book, Presidential Constitutionalism and Perilous Times, recently published by Harvard University Press.
Well, thank you very much. And Natasha, thank you for that. Was a long introduction, but I greatly appreciate the opportunity to be here. Thanks to Natasha for making arrangements, and Ben Bayer, who has the greatest title I've ever heard, Master of Time and Space, and I don't know that you can really top that. And thanks to all of you for coming this afternoon. I appreciate the interest in the topic. And there's the book, Presidential Constitutionalism in Perilous Times. And I should note for the record that it is on Google Books and it is previewed there, and I appreciate that. 38 pages. I guess they couldn't put all of it on yet. I'm going to learn a little bit more about that project later on today. But I also want to acknowledge Google Images for some of the slides today. And it's my first visit to the campus. I've heard a lot about it. Very impressive. You all know that from working here, but it really is a pleasure to join with you. And what I'd like to do is give you an overview of the book, and then keep some time for discussion and questions towards the end. But I think what I'd like to do is start off by talking a little bit about how I got started on this project. Like all of you, we watched the Bush administration react to 9/11 in a whole variety of different ways. And for those of us who have been thinking about, teaching about, writing about constitutional law for quite a long time, as I have done, the way the framers set up our government structure was intended to put in a design of separation of powers and checks and balances that would protect individual liberties. And much of this protection stems from the way power is allocated. And this is something that's very familiar to us in a very basic sense, that if you carve up and divide and separate power, one part of the government is checked and prevented from exercising more authority than one would otherwise expect or want to have happen. And it was really that principle that animated the founders back in 1787. They didn't even include a Bill of Rights in the original Constitution, in part because they felt that it was really a matter of designing the power relationships to protect individual liberties. And when you really think about it, just about every significant action that government takes requires the participation of at least 2 branches of the government, whether it's enacting a law, enforcing a law, appointing a judge, declaring and going to war. At least 2 branches have to be involved in all of those things. Well, as we all became aware during the significant decisions of the Bush administration to address terrorism, it seemed at times that the executive was acting on its own and outside the separation of powers framework. And there was great concern, and we're still talking about it today, that the administration was pursuing very important and necessary security objectives, but at times at the expense of, or at least without significant or sufficient concern for due process and individual liberty concerns. And so we eventually learned that without telling Congress or the American people, the administration decided that the president, acting as commander-in-chief, could overcome enacted federal law and international agreements regarding torture. And we eventually learned that for years, the Bush administration conducted secret electronic surveillance of American citizens in conflict with enacted federal law, the Foreign Intelligence Surveillance Act, again, based on the president's executive power as the commander-in-chief. In addition to those unilateral and, for the most part, secret actions, the administration, as part of detaining enemy combatants, announced that the Geneva Conventions did not apply to them and proceeded to hold them indefinitely at Guantanamo Bay and elsewhere without charge and without any judicial review of their confinement. The president also, as you may recall, early in the administration, created military courts without congressional approval, and again, in conflict with enacted federal law. Now, recognizing that these extraordinary measures were taken when the president and our military and intelligence leaders were under extraordinary pressure to protect the nation from terrorism in the post-9/11 world, I was interested in reaching a better understanding of what the Bush administration had done and how it compared with other presidents when they faced severe threats to the nation. So that takes me to an excerpt from the introduction to the book describing what the book is about. So let me just provide you with that. It says that the book examines executive power during national security crises. It's not about the power to initiate or to declare war, but focuses instead on how the president and the executive branch address danger and respect individual liberty during war. It explores how in dangerous times the separation of powers and checks and balances that affect security and liberty are balanced. The analysis reaffirms the primacy of the executive in responding to threats. It recognizes the important roles of Congress and the courts to check executive abuse and safeguard individual liberty, but it also emphasizes how much we must rely on presidential leadership and constitutional due diligence to ensure the Constitution's promise is redeemed in a system of separated and shared powers. So, my book examines President Lincoln's suspension of the writ of habeas corpus during the Civil War before Congress could act, President Wilson's enforcement of the Espionage Act of 1917 to punish dissent during World War I, President Roosevelt's internment of West Coast Japanese during World War II, President Truman's seizure of the steel mills during the Korean War, and finally, President Bush's torture, surveillance, and detention policies following the September 11 attacks. The book itself is divided into three main parts. The first part discusses different constitutional perspectives on executive power. The second part applies those perspectives to episodes of aggressive use of presidential power during times of war involving Presidents Lincoln, Wilson, Roosevelt, and Truman. And then the third part evaluates President George W. Bush's claims to executive power. So now I'm going to do something that some of us do sometimes, and we probably shouldn't with a book, but that is to skip over the middle part and read at the end part. Some of you may remember that Billy Crystal movie where he's always reading the beginning of the book and then he jumps to the end to see what happened, and so that's what I'm going to do. And let me just give you a sense of where things end up, and then we'll back up from there. So, Lincoln argued that he was operating within the Constitution when he suspended habeas corpus the first time, pointing out that military exigency in the absence of Congress supported such temporary action until the legislature could meet. His administration lost the constitutional argument over trying civilians in military courts outside the theater of battle. Congress authorized and the Supreme Court affirmed the Wilson administration's prosecution of disloyal speech, even though the historical judgment is that the repression was arbitrary and violated the First Amendment. The West Coast Japanese evacuation program had retroactive legislative support and judicial affirmation, but it is now regarded as one of the nation's worst deprivations of liberty and due process. Truman exceeded executive power when he seized the steel mills, but he did not claim the Korean War immunized his decision from congressional control. What made the Bush administration exceptional in this grouping was not the nature and degree of constitutional deprivations, which were serious but arguably less severe than in other wartime administrations. In fact, civil liberties expert Anthony Lewis declared in 2007 that Roosevelt's Japanese internment was very likely the greatest blow to constitutional rights in all the wars and times of stress in American history. Asking whether civil liberties suffered more or less under Bush than under Lincoln, Wilson, and Roosevelt makes for interesting debate but difficult and problematic comparisons. Given Abu Ghraib and Bagram, warrantless wiretapping, and the host of detention issues, for example, extraordinary rendition, secret prisons, and indefinite confinement at Guantanamo, Bush is certainly among the presidents who have claimed significant wartime power and exercised it in constitutionally questionable fashion. What made the Bush administration exceptional was its extreme claims of unchecked unilateral presidential power. The administration's obsession with unilateral executive power was self-defeating. The torture, surveillance, and detention policies came under attack on many fronts, including the courts, the legislature, the press, and the public, isolating Bush in ways that threatened his ability to persuade and lead, the key component of presidential authority and effectiveness under presidential scholar Richard Neustadt's classic thesis. Now, you all will have to be the judge of whether the rest of the book succeeds in supporting these conclusions. But what I'd like to do now is just give you a little flavor of the three major parts of the book. So, the first part, which I mentioned earlier, develops constitutional perspectives that I use to evaluate presidential constitutionalism in Perilous Times. And it actually starts out with a discussion of the presidency in the original constitutional design, and it points out that the framers wanted a single executive and a civilian commander-in-chief. They didn't want a king. But the presidency then was a new office, and the framing and the ratification of the Constitution reflected uncertainty about how the executive would function and the scope of its powers, and as a result, we have been trying to figure that out through experience ever since. I'm not going to take the time now to work through all of the concepts that appear on the slide and in this chapter, other than to identify some basic attributes of what I call executive constitutionalism, including the basing of government actions on, as much as possible, on the broadest basis of legitimacy. That would be executive action authorized by the Congress. And it means sharing decisions with Congress, welcoming oversight and judicial review, and implementing processes in the executive branch that facilitate executive action within the law. The second part takes us to various presidents and how they address security and liberty during wartime. No American president has faced a greater threat to the survival of the nation than Abraham Lincoln. His wartime measures, though, have been debated ever since, including whether they exceeded delegated presidential power and infringed individual liberties under the Constitution, and whether the circumstances he faced were so severe that action based on necessity was justified. So much of the debate about Lincoln centers on the critical 12 weeks between the fall of Fort Sumter on August 14, 1861, and the convening of the Congress on July 4, 1861. During that period, Lincoln summoned the militia, increased the Army and Navy beyond authorized levels, called out volunteers for 3 years of service, spent unappropriated funds, suspended the writ of habeas corpus, arrested persons suspected of disloyal conduct, and ordered a naval blockade of the southern ports, all without congressional authorization. He did it all on his own by declaration and orders. Once Congress came back on July 4, he gave his rationale, his justification for taking these actions, and he said whether strictly or not, these actions were ventured upon under what he said appeared to be a popular demand and public necessity, trusting then as now that Congress would say that was fine and ratify what Lincoln had done. And that's exactly what Congress did do, all against the backdrop of Lincoln having received a ruling from Chief Justice Taney that his initial suspension of habeas corpus, which we can talk about later, was unconstitutional, a ruling that Lincoln elected to ignore. So the suspension of the writ and Lincoln's other actions are analyzed in the book under the various constitutional perspectives mentioned earlier. And here's a brief excerpt on this evaluation of Lincoln's actions. He relied on a theory that under the overriding pressure of rebellion, he could act to the extent of the whole federal government's powers. That is, he was exercising both presidential and legislative powers without the legislature being involved, with the intent of seeking legislative support for actions that had to be taken before Congress could act. He implied that he ran the risk of Congress not backing him up, and in taking care that the laws be faithfully executed. He argued that he did what was possible to execute as many laws as he could, famously asserting that leaving one unexecuted is the responsible course when to do otherwise would leave the rest unexecuted. If full compliance were impossible, he chose the lesser of two evils. Lincoln's actions found support at the time in the idea of adequacy constitutionalism, that the Constitution was sufficiently flexible to allow the president to take necessary constitutional action. Let's move on briefly to President Wilson. Now, as many of you know, President Wilson was the only U.S. president, is the only U.S. president, to hold a PhD. He was one of the nation's foremost political scientists. He'd served as president of Princeton University before he moved into politics, and he had written and updated a classic treatise on American government as part of his academic career. He was a proponent of very close executive and legislative working relationships in domestic policy, but a strong independent executive in foreign affairs. The issue of liberty and security for Wilson arose in his administration's efforts to build support for American participation in World War I. The interesting thing is this: in 1908, before he became president, he wrote the following. He says, "Agitation is certainly the essence of a constitutional system, and absolutely free, outspoken argument for change to an unrestrained criticism of men and measures seems a normal, harmless part of the familiar processes of popular government." That position changed dramatically when, as president, Wilson faced World War I. When he sought a congressional declaration of war in 1917, he warned, and I quote, "If there should be disloyalty, it will be dealt with a firm hand of stern repression." He was concerned that anti-war dissent could undermine a successful war effort, so he went to Congress and proposed the first legislation against disloyal speech since the Sedition Act of 1798, asserting that disloyal persons had sacrificed their rights to civil liberties. Wilson's Department of Justice, which by the way didn't even exist until 1870, didn't exist during the Civil War, used its resources to prosecute over 2,200 individuals during the war under the Espionage Act of 1917 for allegedly disloyal, seditious, or incendiary speech. Nearly half of those people were convicted, and many of them served long prison sentences. An initially skeptical Congress went along with all of this, and the courts, including the Supreme Court, became a partner with the Justice Department in the punishment of political speech. As far as executive constitutionalism is concerned, with Wilson, the book concludes as follows. On the specific question of balancing security and liberty during wartime, the Wilson of Princeton was not the Wilson of the White House. As one leading historian concluded, Wilson was a friend of free speech in theory. He was a foe in fact. This was a cautionary tale. Although the President and Congress together formulated a plan to address a perceived wartime security need, their cooperation did not guarantee that an appropriate balance had been struck between security and liberty. The historical judgment is that enforcement of the Espionage Act caused unnecessary deprivation of civil liberties. Okay, now on to FDR, President Roosevelt. The forced evacuation, relocation, and internment of West Coast persons of Japanese descent were among the most egregious infringements of individual liberties in U.S. history. The episode itself stands as a compelling example of how executive indifference to constitutional concerns and high deference to the executive military from Congress and the courts on national security measures can facilitate dramatic and wholesale constitutional deprivations. FDR's issuance of the infamous Executive Order 9066 set off mass evacuations and relocations, leading to the internment of approximately 120,000 people, about two-thirds of them American citizens. The evidence has shown that racial animus and a mistaken assessment of risks, rather than a true imminent threat, led to this outcome. Congress ratified this executive order by passing a law imposing criminal sanctions for violation of military directives, and the Supreme Court of the United States upheld the evacuation in its infamous Korematsu decision. The Attorney General at the time, Attorney General Biddle, and the Justice Department had raised concerns, but Secretary of War Stimson and the military leadership convinced Roosevelt to order the internment. The book on this score concludes as follows. The Roosevelt General DeWitt evacuation and internment policy was a failure of all three constitutional branches to accommodate both liberty and security in time of war. the executive overreacted, the Congress rubber stamped, and the Supreme Court lost its nerve. President Roosevelt did not seriously question the recommendation of the War Department and General DeWitt for evacuation and internment, arguably the most tragic act of his administration. Although there was debate among high administration officials, Attorney General Biddle and Justice Department lawyers could not overcome the War Department's insistence. There is some indication that Secretary of War Stimson discussed the constitutional issues with Roosevelt, but Biddle later wrote of Roosevelt, "I do not think he was much concerned with the gravity or implications of this step. He was never theoretical about things. What must be done to defend the country must be done." Although Congress was on board, it did not exercise independent judgment. The Japanese internment stands as a compelling example of why presidents must exercise constitutional leadership when civil rights are at stake. Roosevelt did not do so, and thousands of people paid a heavy price, as did American constitutionalism. Now, just very briefly, on to President Truman. The part on President Truman examines his 1952 seizure of the steel mills during the Korean War to avoid a strike involving 600,000 workers to ensure a steel supply for the war effort. Truman claimed he could do this on his own without the approval of Congress. He thought he could do this as the commander-in-chief, but when this was challenged, the Supreme Court of the United States considered his actions to be an incursion on legislative power and counter to previously enacted law called the Taft-Hartley Act. The Supreme Court decision on the steel seizure is significant for a lot of reasons, including the highly influential analysis of separation of powers, suggesting that the president's power varies depending on whether Congress has authorized or prohibited the action in question. The book's take on this particular episode reads as follows. During the steel seizure controversy, Truman described executive powers as limited, of course, by provisions of the Constitution, particularly those that protect the rights of individuals. He and his administration asserted broad claims based on Article II provisions of the Constitution and argued that the cumulative effect of those provisions gave the president power to act in time of crisis. The use of the phrase inherent power connotes extra constitutionalism, but Truman never suggested that the Constitution should be suspended during wartime. His sharp disagreement with Congress notwithstanding, he invited congressional endorsement or repudiation of the seizure order and stood ready to act accordingly. Okay, well that takes us up to the third and final part of the book, and a part that focuses in detail on the Bush administration's policies to address terrorism in the years following the September 11 attacks. This part provides a detailed analysis of the administration's torture, surveillance, and detention policies, including the unilateral formation of military commissions to try the detainees who were being housed at Guantanamo. So we'll have some time to talk about all of these issues during discussion, but let me just say a few words about detention, because detention issues after 9/11 probably drew as much intense and sustained political and legal attention in striking the liberty-security balance during the Bush years. Congress, I conclude, did not effectively check the executive in any of these areas, the torture, surveillance, and detention areas, but the Supreme Court did draw the line on detention and military commissions. So in cases that were decided in 2004, 2006, and 2008, the court said that the president had exceeded authority in denying some form of court review of the legality of confinement at Guantanamo, and had exceeded his authority when he unilaterally set up the military commissions. I think Justice O'Connor had it right when she said in one of these cases, "We have long since made clear that a state of war is not a blank check for the president when it comes to the rights of the nation's citizens. Whatever power the United States Constitution envisions for the executive in exchanges with other nations, with enemy organizations in times of conflict, it most assuredly envisions a role for all three branches when individual liberties are at stake." So the book analyzes these Supreme Court decisions in detail and describes how they prompted Bush, because the Supreme Court pushed back against Bush, pushed Bush to go to Congress for help. The pattern in the detention area proceeded from unilateral executive action to Supreme Court rejection of some of that unilateral action, to the president going to Congress and succeeding in convincing Congress to go along with some of the things that the president and the administration had previously tried to do unilaterally. That's a very quick gallop through the book, the major parts of it. I'm going to finish with a very short excerpt of concluding observations, and then we can open things up for discussion. But again, drawing off the concluding part of the book, I'll close with this. The intersection of separation of powers and individual rights calls for each of the branches to play important and distinctive roles. Because the executive is designed to act more promptly and decisively on national security matters than Congress or the courts, the president occupies a constitutionally strategic position to determine the security and liberty balance. When the president falls short on sharing responsibility with Congress on safeguarding individual rights, corrective checks and balances through legislative action or judicial review do not necessarily occur in time to prevent deprivations. Much, therefore, falls on the president's shoulders to redeem the purpose and promise of constitutionalism. Rule of law constraints through legislation and judicial review are important and necessary but not sufficient. The nation must rely on the president's ability to make sound decisions based on a commitment to constitutionalism. So, I hope that gives you a quick overview and a flavor for this book. It's a book that calls for all three branches to assume a more responsive and responsible position in dealing with the issues that are raised, but recognizes the limitations on the legislative and judicial branches in doing so, and therefore highlighting how critical it is for presidents to bring to their awesome responsibilities a commitment to recognizing that security and liberty go together, and that maintaining our ideals, as our current president has said, is part of what advances our who we are and what our national security interests should be. So I will stop there, and I know I've probably gone longer than I intended, but I'm sure that some of you have questions or comments, and let's just open things up. Go over here.
So I'm by no means a constitutional law expert, but one of the things that bothers me is that we don't have a concept of being at war anymore. The concept of declaring war seems to have gone away. And I think there may be a case to be made for a distinction between, responsibilities or options the president has at war and when we're not at war. Is there any hope for, going back to the concept of declaring war and having a, distinct wartime delineation, or is that gone by the wayside permanently?
This is a great question, and it has to do with the status of being at war, and the fact that the Constitution itself explicitly addresses this question by on the one hand, saying that Congress has the power to declare war, and on the other hand, that the President serves as Commander-in-Chief. The last formal declaration of war in the United States was for World War II. And yet, we all know that our country has been involved in armed conflict on a number of different occasions ever since. There was no declaration, for example, for the Korean War. No declaration for Vietnam. There were resolutions that were passed by the Congress, for example, the Persian Gulf War and for the Iraq War. They were authorizations, joint resolution authorizations for those wars, but no formal declaration of war. And there are those who would argue that a return to what the framers intended through the explicit language, oftentimes you don't have explicit language addressing these issues, but you actually do here, is something that should occur. Others have argued that, well, as long as, whether you call it a declaration or whether you call it a joint resolution, if the two houses of Congress have weighed in and given the President authority, as they did in 2002 with respect to Iraq, that's the functional equivalent. But I think your point goes even further, which is to say, when we're facing threats to the country and hard choices have to be made that affect our security and our liberty, shouldn't there be a formal dialogue about the context in which those decisions have to be made and how far the government can go? And having that dialogue and recognizing in the sense of both branches addressing that issue should be important in shaping the response to these issues. I think there's a growing realization that that needs to happen. Some have argued, and I agree with this argument, that we should be looking at revising our national security legislative framework to anticipate some of these issues in advance. One of the problems we faced post 9/11 was the need to make very hasty decisions. It wasn't that those decisions could be avoided, they had to be made. But the argument is that we should be anticipating better than we have the need to respond in particular ways by creating a framework through which the legislative and executive branch participants can go about addressing these issues. And I think that may be one answer to the issue you raised, but it's, you've put your finger on a really critical point. Yes?
So, what's your assessment in sort of, all five presidents' cases, that if they had not exceeded what's generally agreed as, sort of the constitutional limits, would it have been a disaster or not?
I think that
Did they really improve the security of the country?
Right. I think the judgment of history has been that these presidents in various of these instances that we've talked about did not have to go as far as they did to address the security issue at hand. Probably the most extreme example would be the Japanese internment. Which I think at this point, the assessment now, and quite frankly, even the assessment then, among those who looked very closely at the situation, is that the military in the executive branch overreacted, and that having a more individualized assessment of potential risk would have been the appropriate way to go. I think we learn from each one of these situations. We didn't have the kind of suppression of so-called disloyal speech After the Wilson years, we didn't have suspension of habeas corpus. After the Lincoln years, we have certainly not had anything approaching the internment of the World War II years. So I think presidents in the country have learned from these episodes, but when we come under severe national security pressure and threat, we're not dealing with the same circumstances each time. And so we tend to fall into this pattern of reacting, and sometimes with some measures perhaps overreacting, realizing that that happened after the fact and saying, well, let's not make that mistake again. And then we tend to do that. And I think maybe what I mentioned just a minute ago, by trying to anticipate and coming up with a better set of framework guidelines on how to handle some of these matters. For example, I didn't address the interrogation issue during the Bush years, but we now have, which we didn't have before, a task force of experts who are looking very closely at what exactly the interrogation policies of the United States should be. Outside an immediate need to act and coming up with a more clear, accountable, and engaged system, not the kind of unilateral and secret decisions that were made in the Justice Department in 2002, but a dialogue that includes both the Congress and the executive branch to give some legitimacy and some transparency to that particular process.
Over here. So particularly around election time, a lot seems to be made of Bush being a problem or the problem, and that having a new president somehow would fix things. And while I'm personally glad to see Bush gone, to me the problem wasn't Bush. The problem is the system that allowed Bush to do everything that he did. What can or should be done to fix this? The founders, they didn't dislike a particular king, they disliked monarchies, so they formed something new. This wasn't a problem with a particular president. This is a systemic problem.
Yeah, well, I'm glad you raised this point, because that was really one of the major purposes of writing this book, is to say, look, there's been a lot of criticism and debate over how the Bush administration addressed a variety of these issues over the last 8 years. But this is not a new set of issues. These are issues that we've confronted and wartime presidents have confronted throughout our history. And so that's really one of the messages of the book. Another message of the book is that in national security crises, what we've seen under a variety of administrations is a Congress that pretty much backs off and defers to what the executive wants to do, and courts sometimes checking executive power, but oftentimes, because of the way our justice system operates, coming too late, really, to address the immediate situation, but nonetheless setting a precedent for the future. And the thrust of my argument is that even if Congress and the courts are functioning as well as they possibly can in addressing these issues, the institutionally strategic position that the executive has in addressing these issues is such that we are going to have to rely on the president and the administration to act effectively in keeping us safe, but doing so in a way that is also shows concern for the basic values that we have. That's the way those issues are framed. I mentioned framework legislation earlier. I think it's important, but I don't think it answers the whole question. Ultimately, I think it comes down to being very careful during the course of a presidential election in selecting people for that office who will exercise a good judgment and will bring together a team of people who will exercise the kind of sensitivity to constitutional issues that I think these issues demand, and building into the executive branch a kind of internal dialogue and debate, its own branch checks and balances that are necessary to avoid the kinds of things that happen under Bush. I mean, the torture memo of August 2002 was hatched in secrecy. We didn't even know about it until it was leaked in 2004. And the secret warrantless wiretapping program was authorized by the president, again in secret, in late 2001, only to be disclosed in December 2005 by the New York Times. That's not a good way to make policy. I realize that national security requires a certain amount of confidentiality to be effective and for it to work. But I think that at the same time, building in the systems for decision-making, dialogue, and making sure that the Congress is engaged in a meaningful way are critical steps to avoid some of the pitfalls we fell into during the Bush years. Yes?
Is there anything in the historical record about how you sort of stand down from these sort of decisions? How do you go back on it? It seems like in the previous examples you've given, a lot of them are tied to a war. So the war's over, okay, we can go back to having habeas corpus, or you can go back to not interning people anymore. What does that mean for the current administration and how they're going to stand down, given that the war on terror as such doesn't seem to have to end?
Okay, again, very good. I talk about this in the book. It's true that in some of the examples of the book, the presidents themselves saw the emergency as a discrete period of time. Lincoln didn't know when the Civil War would be over, but he said, I've taken some measures that I want to emphasize are absolutely temporary measures. Other presidents said the same. What makes the more recent experience different, and you put your finger on it, is that the war, so-called war on terrorism, has been deemed to be a perpetual war. And if that's true, then if measures are taken that are deemed to be extraordinary measures, does that really mean that extraordinary measures in fact have become ordinary measures? And are they the permanent state of the security-liberty balance? And it's that feature of the times in which we live that I think create a different challenge than some of the others that were described in the book. Yes?
So in reaction to what you said recently, as a first question, the War Powers Resolution, as I understand it, was an attempt to do sort of what you said, which is to sort of an ex-ante set of rules between Congress and the executive. But from what your follow-up answers were, I get the feeling that you've ultimately, from the book, decided the executive is always going to be the ultimate arbiter of our conduct, and that internal checks and balances are the real answer. Is that right? Is the War Powers Resolution something like that kind of nice to have, but ultimately not going to be a long-term solution, or is something like that really what you're sort of getting at?
Well, the War Powers Resolution was adopted in 1973, largely in response to some things that were happening in the war in Southeast Asia, the war in Vietnam. And it was an effort by the Congress to reclaim what it considered to be its constitutionally appropriate role on the issue of initiating armed action. Now, I guess point number one is that the War Powers Resolution and the issues that you have raised are extremely important questions. I put those aside in this particular book. I didn't address the issue of the power to initiate or defend in terms of the exercise of war powers. My project was focused more on, okay, we're in an armed conflict. How do we make decisions about security issues in that particular context. But speaking a little bit more directly to your question, the War Powers Resolution is actually an example of the sort of framework legislation I was talking about earlier. It attempted to set up a process by which the Congress would get notification from the executive of the need to take military action, that the Congress, after a certain period of time, would be in a position to block going forward. It was designed to build consultation between Congress and the executive to restore that kind of interbranch interaction involving the war decision. Presidents have, especially initially, President Nixon vetoed the resolution, claiming it was unconstitutional. Subsequent presidents have resisted it, but there's been kind of a good faith effort to make it work. More recently, I think the experts in the field have thought that even the War Powers Resolution and the way it sets up this process and dialogue should be rethought. But the common denominator seems to be that although the president certainly has to be in a position to deal with sudden attack and to act very quickly, beyond that situation, I think the common denominator is that decisions that are as fundamental as whether we're going to put our people in harm's way should not simply be made by one person. That it should be a more democratically accountable decision, and that's consistent with what the framers intended from the beginning. So I think you're going to see some interesting things possibly happen relative to the War Powers Resolution. So thank you. That's a great question.
Question on VC.
Oh, we're getting something from somewhere.
Yeah, voice from SF actually. Brian from San Francisco, thank you for joining us. Had a question about not, I guess, past actions or past practices, many of which have been sworn off by the new administration, such as torture, such as warrantless wiretapping. Focused actually on preventive detention, which appears to be with us for the long term. I was hoping you could explore that in a little more depth and see whether that's something that we can actually reconcile with your view of executive constitutionalism, if that can be done within a framework of respect to the separation of powers, the rule of law, and so forth.
Okay, this is Brian from San Francisco question. Great question, by the way. This is an issue that President Obama spoke to last month in a speech that he gave at the National Archives. And he was talking about the challenges we face in dealing with the Guantanamo situation as it now presents itself. And he indicated that there are some detainees at Guantanamo who can be prosecuted in U.S. courts in a traditional prosecution context. There are some who have violated the laws of war, who President Obama would like to see prosecuted in the military commission system, although he sees some reforms that should be implemented in the military commission system compared to the last administration. There are some who have been cleared to be returned or to leave Guantanamo and return to other countries. And as he pointed out, about 2/3 of the people who have been held at Guantanamo were released by the previous administration. So the process of taking people out of Guantanamo started long before the current president took office. But he also identified the hard case, which is what I think Brian was referring to. And the hard case consists of those individuals at Guantanamo who can't be prosecuted in our civil court system, in the federal courts, can't be prosecuted in military commissions, either because of evidence issues, legal issues, whatever they happen to be, but they can't be prosecuted. But nonetheless, there is strong reason to think that they continue to pose a very significant danger to the United States. So what do you do in that situation? And President Obama has asked for a review of. He's saying, I don't want to be releasing people who pose a dangerous threat to our country. But on the other hand, we're not in a position to try them. Are there a fair set of standards with clear procedures and a process of accountability assessment that would enable a more prolonged detention in these circumstances? He's thrown that question on the table. And it's a difficult question because on the one hand, there are those who would say, well, you know, if they haven't violated any laws and we can't prosecute them, as a general matter, we don't hold people. But on the other hand, there are those who would say, but wait a minute, there is still, our intelligence agencies, our military have determined, and there is evidence to determine that these people are still very dangerous people. So that's the hard case. And the president has said, look, I'm not going to decide that. I don't think one person should decide that, which is sort of consistent with what the book says. These are not questions that we're not under a situation where he has to decide right this second. He needs to work with the Congress and try to work through the issues. But it poses some really serious questions of liberty and security, and I think that's the hardest detention question that faces the administration today. So, Brian, thank you for raising that. I think that's a very timely question, and it's the question the President has addressed recently, and I think we'll be hearing a lot more about it over the course of the next few months. Thank you. Yes.
Of course, I was wondering how much do you think the kind of overstepping in constitutional terms is related to the kind of lack of accountability to the people? And what I mean by that, there's lobbyists who heavily influence who get elected, and it's important to have those people backing you. And because of that, because of the way our system is set up, appeasement of those groups is very important. I mean, I think you'd see something very different right now if all the lobbyists, especially high-profile ones who are saying impeach Bush, versus just people like us saying something like that. And like the war, when we went to war in Iraq, there were huge demonstrations there, and a lot of people saying that the reasoning for it was inaccurate. There weren't weapons of mass destruction. But no one in the lobbyist arena had issues with it per se. And even with like Wilson and the issues there were a lot of civil unrest at the time. There were a lot of sit-down strikes. The people who had the president's ear, wanted stuff like that suppressed so they could make their money and have the factories going and not stop because of things of that nature. So I'm wondering, is it like a failure in democracy here in terms of more accountability from the executive branch and the legislative branch to the people they're supposed to represent?
Well, I'm going to respond to that question by putting it in the context of the last 8 years. And although I wasn't able to go into as much depth in my presentation as I do in the book, Congress does not come off well in my analysis of the issues raised in this book. The role of Congress, and although there was some effort, definitely, but the role of the Congress in these issues is one of engagement, in willingness to address these issues, and in being part of the dialogue. They are, they are the elected representatives of the people. They represent diverse constituencies. They hear what people are concerned about at the grassroots level. And as I mentioned earlier, I think a principle of executive constitutionalism is that the legitimacy of what the executive branch does is at its highest when it is the product of legislative authorization. But our history has been such that in national security crises, Congress has a tendency to pretty much defer to what the executive does, and to a certain extent with good reason, because as I've indicated earlier, the executive branch, the president, the military, law enforcement, intelligence agencies, that's their job, is to react and to keep us as safe as we possibly can. And in an exigent situation, we expect them to act and to keep us safe. But when it comes to formulating the longer-term response, those kinds of decisions, and the decisions that were made in this administration in terms of interrogation, detention, and torture, were not decisions that had to be made overnight, and they weren't decisions that had to be made in a week or a month. They were decisions that could be formulated over a period of time. And when that is the case, engagement with the legislative process is very important. But it takes two to, it's a two-way street.